This is Greenwood's Legal's Employment Law Nowcast, Episode 1. Today we're talking about the working time regulations, TUPE, and restrictive covenants. Enjoy the podcast. Hello and welcome to our new podcast. It's our Employment Law Nowcast, and this is going to be a regular series of podcasts where we will be joined by various people discussing exciting things that have happened in the world of employment law. So by way of introduction, I'm Michaela. I'm a solicitor in our employment team here at Greenwoods, and I'm joined today by John Macaulay and Keith. Do you want to introduce yourselves?
Yes, I'm John Macaulay. I'm head of the employment team at Greenwoods.
And I'm Keith Williams. I'm a partner in the team as well.
Great. So today, like I say, it's the first in a series, but today some quite exciting stuff has been happening in relation to Brexit and retained EU law, and in particular the retained EU law bill. And we did some training recently, didn't we? That I made quite a big deal out of the retained EU law bill, and that all of the retained EU law was going to be revoked, and that was the plan. But then a couple of weeks ago we heard from the government, kind of out of the blue, the first real change since Brexit, and they said that actually they were going to flip that plan on its head, and the retained EU law was effectively staying now, other than things that they said weren't. So it was a bit of a U-turn. Linked to that, there were some quite significant proposed changes, we think. The first one, kind of stemming from the working time regulations. There was some stuff about TUPE as well that we'll come on to, but the working time regulations stuff, the most significant potential change is to do with rolled up holiday pay, and we'll spend a bit of time talking about that today. So just starting from the start, what exactly is rolled up holiday pay?
Well, it's something that we haven't really had properly in the UK since about 2006, so getting on for 20 years ago now, when it was outlawed by a ECJ, so that's a European Court of Justice decision. To put it simply, rolled up holiday pay is where instead of people working and getting paid their normal pay and then taking time off and still getting their normal pay, what happens is that while they're working, a certain additional element is added to their normal working pay as rolled up holiday pay, which pays them for when they take their holidays. Of course, the flip side of that is that when people actually take their holidays, they don't get any pay at all because they've already received it.
Okay, so that is quite a significant change then, and it's been kind of, I know there's been changes in relation to holiday pay and how it's calculated over recent years, but since 2006, that is quite a recent change. Will employees have a choice about this if it comes in?
Well, we've got the consultation document from the government now, and they make quite interesting noises at the start that it's giving employees an opportunity to get all of their pay when they're actually doing their work. But when you read through in a bit more detail, the consultation makes it clear that the intention of the changes is that it will be for the employer to decide whether they're going to pay people for holiday as they take their holiday, or whether they're going to use a rolled up holiday pay model. Now, of course, for any employee, how they receive their holiday is going to be a matter of what their contract says. So it's not going to be as simple as employers simply deciding to change how people receive their holiday if they're already working under a particular contract. But for new employees, it will be open to employers to decide whether they're going to use a rolled up holiday model or whether they're going to pay people holiday as they take it.
Right, and so do you think, obviously you mentioned it's a consultation at the minute, so we don't know, although we've got a fair idea of what the government are thinking. Do we think this change will be popular with employers?
I think it might be. There are issues with the holiday pay regime as it is at the moment, because it is quite strict and quite there's not a lot of flexibility in it. So, for example, if you've got someone who is an atypical worker who works short hours occasionally, take my daughter for example. She works at a well-known fast food outlet. She only works when she's not studying. She works 1 or 2 shifts a week of 5 hours a week. And she, because it's what the law says, accrues holiday during those periods. So each 5 hour shift she works, she accrues a little bit of holiday that she builds up and builds up. Of course, she doesn't really need to take that holiday from her work at the fast food restaurant because she's only working maximum of 2 shifts a week anyway. So in her case, instead of accruing holiday that she could then take and get paid for, if she were to get her actual hourly rate of pay increased to take account of the holiday, it would probably actually work better for her, and it would certainly reduce the administrative burden on her employer. So I think in circumstances like that, where it's applied to people who are working sporadic hours, so students, other people that are working erratically, I think it could actually be welcomed both by employers and employees.
But it does seem to be the student kind of market that we're thinking would be the ones that would appreciate this the most, maybe, because otherwise it is a significant change that's proposed.
Yeah, that's right, and it's quite firmly dealt with in the consultation that this is a real benefit for people who are working those unusual hours. But and I think we're probably going to be talking at some point during the podcast about the fact it's not just limited to people working atypical hours, and in theory, what the government are consulting on are introducing it for everyone, including people who are on full-time contracts.
So, kind of linked to that, then, historically, and the case that you mentioned, the ECJ case, I think the one you're referring to was a Spanish case. Am I right? That kind of said that the part of the reason for people needing to take their holiday was to ensure that they were properly rested. Am I thinking of the right one?
Yeah, that's it. I think it may well have been a Spanish one. Even I can't very easily remember all the way back to 2006, but it may well have been a Spanish case. But yeah, John, that is an issue, isn't it? For a long time, with the EU view of these cases, there's been a big health and safety issue.
Yeah, I mean, the whole of the working time regulations as interpreted through the EU is really about health and safety. It's all been about making sure that people have adequate rest, making sure that they take rest breaks, making sure that night work is the right length, all of that kind of thing. And it's all been viewed through a health and safety lens. And so all of the case law has then grown up with that background.
Geared
Um,
towards it, that
yeah,
kind of thing.
and I think what's quite interesting about this idea of rolled up holiday pay is that it's kind of been outlawed as a result of the fact that, as Keith has said, it kind of runs contrary to the idea of encouraging people to take their holiday. So it is quite a significant step in a different direction. One that I think possibly a lot of employers will quite welcome, but query whether it will do what it's supposed to do from a health and safety perspective.
Yeah, and I suppose particularly we've spoken about, haven't we, how for atypical workers, students, that kind of thing, they might really benefit from it. I know for me personally, I'm full time here. It would be very odd to go on holiday and then be paid, well, not be paid for the time that
When you're
I'm
actually on
on
holiday.
holiday.
Yeah.
Yeah, it's not the greatest incentive, I don't think, to take holiday, and particularly as with the cost of living crisis, that kind of thing, maybe other people might be discouraged from taking it, which is exactly your point, leading back to the health and safety thing. So that's very interesting.
I think for me, it's the point that Keith made about introducing it potentially for anybody.
Yeah.
I think it kind of makes sense for irregular hours workers, 0 hours contracts, and things like that. It feels like it makes sense. But if we then moved to a situation where it could be for anybody, I think that's where there's a potential risk that the health and safety angle could become more problematic.
And there's no kind of indication that we've seen in the consultation about changing those kind of health and safety rules, as far as I've seen. So yeah, that will definitely be something to bear in mind if the rolled up holiday pay does come into force as they're proposing in the consultation. Have we seen anything about how rolled up holiday pay might be calculated, what might be included? Because I know for other holiday pay calculations, there's been a whole load of case law about what it should and shouldn't include. So, has there been any indication about that so far?
Yeah, so as you said earlier on, haven't really seen anything much in terms of impact on employment legislation post Brexit. But then this this consultation is actually really significant because not only does it introduce that point about rolled up holiday pay, but it also seeks to kind of combine the two different types of annual leave that we currently have. So we've got the sort of 4 weeks that's required by Europe, and then we've got 1.6 weeks that's in addition to what's required from Europe. And the two are treated differently for a whole variety of reasons in terms of how you potentially calculate the holiday pay, whether it can be carried over, all sorts of different things. And one of the key provisions of this consultation is the idea of combining those two types of holiday. So effectively, what you get is a period of 5.6 weeks, and then standardizing the rules, largely standardizing. I'll come back to that in terms of exactly how you treat them. Now, I mean, I don't know about you, Keith, but I think it makes a lot of sense to have one set of rules
Yeah.
for the whole of the holiday.
Seems logical, doesn't it?
Well,
On the face of it.
it's been really odd, hasn't it? How we've had to deal with holidays since the government, for fairly sensible reasons, introduced the additional pay. It was because historically, when the 20 days was introduced, some employers saw an opportunity to include the 8 bank holidays in that 20 days, which was effectively not achieving what it was supposed to. So it was a sensible thing to increase the minimum holiday by those 1.6 weeks, but how it was actually done led to a bit of a mess.
And
Yeah,
it's interesting as well, isn't it? Because that kind of some employers including the 1.6 weeks again links back to the health and safety point that we were talking about, that everyone was quite rightly really quite adamant that people should take their holiday to ensure sufficient rest and the health and safety thing. So, yeah, it really is a move potentially.
yeah, and I think the intention is to create this kind of standardized picture. And then also the proposal is instead of having a situation where, as is currently the case, the 4 weeks annual leave, which is required under European law, effectively employers have to be paid their normal pay, the pay that they would have had if they'd been working. And European case law has effectively meant, as we've seen all sorts of cases on it, that might include things like bonuses and commission and all of that sort of stuff. Whereas the 1.6, the additional 1.6, could potentially be paid at basic pay. Now, you immediately have a real issue for employers as to, how do they potentially have two rates of pay for two different periods of holiday, which period of holiday is being taken first, all of that sort of stuff. So a lot of employers may well have just decided to pay everybody at the same rate. But what they're looking to do now is, as part of this proposal to create a standardized period of holiday of 5.6 weeks, they're also saying that they're using this consultation as an opportunity to discuss what rate of pay should actually apply for the whole 5.6 weeks. Now, it's really interesting because when you read the consultation, it's indicated that this is just a way of consulting about it. It makes the point that obviously businesses might feel that if you went for normal pay for the whole 5.6 weeks, that could put a really significant financial burden on a lot of businesses. And on the flip side, if you went for basic pay for the whole 5.6 weeks, it could result in significant hardship for employees. I mean, in terms of which direction it might go in, obviously we don't know yet, but there's a little bit of a signpost in there because it just kind of finishes that particular section with a comment about that normal remuneration isn't very readily defined, and it might be very difficult to write normal remuneration into legislation, which kind of hints to me that we might be looking at something where it's going back to basic pay. And obviously, the position so far has been that the additional 1.6 weeks has been at basic pay, and that there hasn't been a move to align that with the normal pay that were required for the other 4 weeks. So does that give a sign as to where we might be going with that particular part in terms of calculation?
Yeah, because that was the one bit that wasn't governed by the ECJ cases, was it? So that was the one bit that was based on UK law alone. Yeah, so you've got to wonder if that's the bit that has always been paid at basic pay, and it was only ECJ decisions that said the other stuff had to be paid at normal rates of pay rather than basic rates of pay. Yeah, it does suggest the wind might be blowing in one direction there, doesn't
Yeah,
it?
I think if I was a betting man, that's what I'd put my money on,
Yeah,
I
I think
think.
so.
It'll be interesting to see. Does that mean you're going to be responding to the consultation?
I don't know about that.
Does anyone ever respond to the
I'm not.
consultation?
I'm not sure. But I think the other thing is that there's also the carryover provision. So we've
Yes.
got, the 4 weeks leave under European law generally wouldn't be carried over unless in certain circumstances where somebody's not been able to take the leave. So, for example, if they've been on maternity leave, or they've been on sickness
Yeah.
absence, whereas the 1.6 could be carried forward by agreement between the employer and the employee. So again, they're looking to kind of standardize things, although there is a slightly odd provision in the consultation which suggests that they're creating a standardized picture, but they still seem to be suggesting that the 1.6 can be carried over, but the 4 weeks potentially couldn't be carried over except in those limited circumstances, which seems a little bit odd. Whether it's a slight nod to the health and safety angle of things, of not carrying over the whole of leave and trying to make sure that there's some element of requirement for employees to actually take some leave during a year, I'm not sure. But why that would be 1.6 and 4, I'm not sure. It just feels like almost like a sort of forgotten part of this standardization. So I'm not quite sure where that will end up.
And I suppose maybe the last point then in relation to the working time regulations, something I spotted was this thing about record keeping. So I don't think they're proposing to make any changes, for example, to the rest breaks required under the working time regulations, that kind of thing. But there is a requirement at the minute for employers to keep records of time worked. Query how readily that is undertaken by employers, even though there is that obligation. But I think I saw something in the consultation about taking away that requirement to keep records. What do we think about that?
Yeah, so there was a 2019 case, Deutsche Bank case, which basically required employers to keep objective, reliable, accessible records of certain parts of the
Yeah.
requirements of the working time regs, as you were just saying. So it's things like the requirement to have a maximum number of hours in a week, um, daily rest, weekly rest, those kinds of things. So the idea was you need to have records of that in order to prove that it's actually happening.
It's
And
difficult though, isn't it?
it
Really difficult to
really
keep
did.
those records.
Yeah, absolutely. I mean, in an environment where you may be clocking on, clocking off, then fairly easy. But for most people in sort of office environments, etc., a lot more difficult. And I think that the indication in the consultation is that, and interesting, they say as a result, particularly as a result of the post-pandemic situation and the burden that businesses are under there, and also as a result of the Ukraine war, is what they say in the consultation. Particularly now, they think that burden of record keeping is cumbersome and something they want to remove. So basically, they're proposing, as you say, all the rest breaks, everything that's required will still be there. There just won't be a requirement to keep a record of it.
And what do we think the potential impact of that might be? Do we think there will be one? For me, it seems um, a bit odd, maybe, to take away this requirement on employers. Could it be open to abuse by employers? But I don't know. I feel a bit mixed about this one because if people aren't really keeping records at the moment because it is so difficult, I don't know. It's a bit of a
Yeah,
cyclical argument, I suppose.
it does feel a little bit disingenuous
Mm,
to say at the very outset of the consultation that the government are absolutely committed to maintaining all of those rest breaks, and then in the next breath they say, but we're going to remove the obligation to maintain the records that will allow the employees to prove whether that's happened or not. But yeah, as you say, in reality, employers are generally not keeping those records in any event. So will it actually have a practical impact on a lot of employers? Probably not.
I agree. I mean, I'm not quite sure what the Ukraine war
No.
has to do with the record keeping requirements
did
under the
wonder.
working time regs, but it's kind of a general point about burden on business. But I think it's one of those provisions that came in, and because it was just so difficult and almost impossible for some businesses to be able to do anything about, I think it's largely been ignored, except in those organisations where they already have some kind of clocking in or clocking out system. So probably not a great impact, I wouldn't
No.
have thought.
The consultation, we're not quite done on the consultation yet, but it closes early July. So, yeah, as always with these things, the devil will be in the detail. This is a good signpost of what the government is thinking and where they're going. And obviously, we've analysed quite carefully quite a lot of it. So, this is as much as we know for now. Particularly on the working time regulations piece. There is also a piece in there about TUPE. So, and kind of consultation and election of representatives. We've got the micro business exemption at the moment, haven't we? But there's something in the consultation that is it seeking to amend it or expand it slightly? What's happening?
Yeah, so I found this one quite interesting because we often have clients who are talking to us about consulting with small groups of employees who are transferring from one business to another, or as a result of a service provision change, for example, in a contracting out of catering situation or that kind of thing. And there's this requirement under TUPE generally that you have to elect appropriate representatives for those transferring employees. And in most cases, it doesn't matter if you had one employee, theoretically, you've got to elect a representative. Well, clearly, you know who that person's
Yeah.
going to be, but it's slightly bizarre, particularly with small groups of employees. But we did, as you say, have this micro business exemption. So businesses with fewer than 10 employees didn't have to elect representatives. They still have to do the informing and consulting of the employees, but they can do it direct.
To get around that issue that you
Yes.
just said about them basically electing themselves.
Yeah.
And that micro business exemption, that's entire employees within the business.
Yes,
That's
right.
Yeah.
Yeah. So it's about how many employees the business has.
Yes.
If the business in its entirety has fewer than 10, then you don't have to elect representatives for whoever is transferring. Now, obviously, in a business that size, there aren't going to be that many transferring because there's only 10 in the entire business. So it's a very limited exemption and not really one that we come across very much in terms of our practice. What's more common is larger businesses who are transferring small numbers of employees but still have to elect representatives. And that's really what the proposed changes are about. So what they're seeking to do is extend the micro business exemption so it's a small business exemption. So in other words, businesses with fewer than 50 employees wouldn't have to elect representatives. And also, they're also introducing something where a business of any size who's transferring fewer than 10 employees, so then we're talking about the number of employees who are transferring, not the number of employees in the business. So if fewer than 10 are transferring in a business of any size, again, there's not a duty to elect representatives. Now, there is one point in amongst all of this that there's no duty to elect representatives or consult with them unless you've already got representatives. So if you have some kind of works council that has the appropriate power to be consulted, you would still be expected to consult with them.
Okay.
That could lead to some slightly unusual arguments that we're not familiar with now of businesses potentially trying to argue that their reps aren't appropriate, so then they don't have to consult with them for small numbers, whereas normally at the moment
minute
you're in
it's-
the opposite
yeah.
way round of saying we think our representatives are appropriate, so we don't need to elect more. So it's kind of expanding that opportunity for businesses to consult direct with employees rather than elect representatives. That's the key.
Yeah, again, it seems very helpful on the face of it, but do we think potentially this kind of, I suppose it could be the case whenever you've got these kind of cut-offs of 50 employees, etc. Do we think it could lead to arbitrary results in some
Yeah,
cases?
I think whenever you have limits below which you could do one thing and above which you do another, you can end up with arbitrary results. So, for example, here, yeah, you could have a huge employer with 10,000 employees who are only transferring 9 people, and you don't need to elect representatives, whereas a smaller employee, say with 51 employees, would need to elect reps when they're only transferring 10. So actually, the numbers, you get some slightly strange results. But I've got to say, I think all in all, this is
Yeah.
a sensible change. I'm dealing with a TUPE for a client at the moment where they're a large business, 3 people are transferring, and they are going through a little bit of a pantomime of all 3 of those people electing themselves as representatives, because of course they all want to have their own say in such a small transfer that's directly affecting them. But without that election or something that we can point to and say that an election has taken place, there would be a technical TUPE breach. So I think all in all, this is a really sensible change.
Yeah, I agree.
Great. Okay. And then probably the last thing for today, restrictive covenants. So this hasn't come out of the consultation, but it is kind of something that was announced that the government are thinking about doing. So at the minute, within certain reasons, we all know restrictive covenants are kind of can be kind of fiercely litigated to decide whether they are enforceable or not. But the headline here is that the government are thinking about limiting the length of non compete restrictive covenants to 3 months, which is quite unusual, isn't it? Because governments don't, or kind of legislation doesn't normally interfere with private contracts between individuals and employers. So potentially this could be a big change as well. Having read some of the stuff around it, I don't think we're quite clear. I've got a good idea, but I don't think we're quite clear about exactly what we mean by non-compete. Have either of you seen anything kind of similar?
Yeah, I mean, I think it's normally restrictive covenants are kind of divided into different parts. So you'll have stuff to do with confidential information, and then you will have some provisions that restrict literally competition. So in other words, joining another business in any capacity that competes with your current business, and then there'll be provisions that stop you from soliciting clients, soliciting suppliers, then provisions that stop you from dealing with suppliers or clients, and then there'll be also stuff to do with poaching employees. So they're kind of different pieces. Now, the way it's phrased, because there is a separate reference to non-solicitation, is we think that what this is referring to is a limit of 3 months on pure non-compete. So
That's how I read it
yeah,
as
I
well.
think what
Yeah.
we think it will mean is that you can't have a contract that says you can't go and work for a competitor for a period of more than 3 months. In other words, that's the length of the restriction, but you could still have, for example, a 6 month non solicitation, non dealing, non poaching provision. We think that's what it means. And I think that probably makes sense because non-compete clauses have been pure non-compete clauses have always been the most difficult ones to enforce anyway, and they're probably the ones that are most they run most against that idea that competition is a good thing. So if what you're saying is, well, there's actually a client or a customer or a supplier that you've got to know, and it's reasonable for us to stop you from then using that information to take them away, that's kind of fair enough. But just saying you can't go to a competitor and compete with us feels almost kind of against public policy. So I wouldn't be surprised if that is where we end up, but we're not absolutely certain of what it means just yet.
And when I'm reviewing contracts, that kind of thing, I quite often see non compete clauses that are longer than 3 months in length. So do we think this might have a potential quite a big impact?
Well, yeah, it could, I think. And as you say, it's pretty common to see non-compete clauses of certainly 6 months. I'd say much longer than that are quite rare, but in certain industries, they really do happen. I've certainly got experience with the insurance industry where longer non-compete clauses are in there. What is going to be really interesting to see if and when this law is introduced is how it's actually implemented, because the way the courts work at the moment is if there's a whole clause of some sort of restrictive covenant in there, they can cross it out if
Get
it's
your
unfair.
get your blue pencil
Yeah,
out,
they
don't
call it
you?
the blue pencil rule, and they can cross out a whole clause and change things that way. But what the courts can't do is change a bit of a clause. So in this case, where if you've got, and you will have across the country, you will have tens, hundreds of thousands, possibly millions of employment contracts that have non-compete clauses that run for more than 3 months. Now, at a stroke, all of those non-compete clauses, if left as they are, might become invalid because they don't comply with the law as it's then going to say, and it won't, under the normal rules as they stand at the moment, it won't be open to the courts to say, well, this clause says 6 months. 6 months isn't allowed anymore, so we'll change it to 3. That simply isn't how the courts are allowed to operate at the moment. They would have to say, in the case of a 6 month non-compete, if the law restricted non-competes to 3 months, they'd have to say that's unlawful. It wouldn't be open for the courts to say, well, what they must have meant is 3 months, and so we'll change it to that. So it will remain to be seen whether legislation that is introduced to deal with this actually gives that provision to say that where there are current clauses that say more than 3 months, they are automatically um, changed into a 3 month restriction, or whether they effectively allow every existing clause that's in excess of 3 months to fall away. Now, that is something we'll have to wait to see. I personally am slightly skeptical as to whether we'll ever see this piece of legislation come into force at all.
Out of all the things we've discussed today, it
Yeah,
feels
well,
maybe not this
the
one.
the difference is that the other things that we've just talked about, the working time regulations and the TUPE regulations, clues in the name, they're regulations, and so they can be changed. They're statutory instruments. They can effectively be changed by the Secretary of State with very little input from Parliament. They can pretty much be steamrolled through very quickly. Whereas this, as you said, Michaela, when you're talking about legislating to fundamentally change how employers and employees are allowed to contract with each other in private contracts, that is going to take primary legislation. And there is a note on the policy paper that announced this change that this will be implemented when parliamentary time allows. Now, we've only got a maximum of about 18 months until the next general election, and I think the government are going to be pretty busy between now and then. So whether this will ever get to the front of the queue as being something that needs to take up a lot of parliamentary time, yeah, I'll wait to be proven wrong. But I wouldn't be surprised if this never sees the light of day in reality.
So we've covered quite a lot today. There's a lot going on suddenly in the world of employment law, and we'll continue to keep you updated. We thought it was an ideal chance to start our podcast. Obviously, this has been episode 1. We're going to try and do regular podcasts, and also there's our email updates as well. So please stay tuned for further information. Thank you.